All right. Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court number 2. My name is Judge Terrence Holmes, and I'm the presiding judge here in County Court number 2. You have been asked to come to court today for a criminal case. It is a misdemeanor criminal case. Now, criminal cases are divided into felonies and misdemeanors. Your misdemeanors are normally referred to as your petty offenses, whereas your felony cases are normally referred to as your serious offenses. It does not mean that your misdemeanor is not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, when I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Yes, ma'am, you need to come in?
Yes, sir.
You just come in and have a seat, sit next to a clipboard. There should be some clipboards on this side. Okay, now, if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, or and a person can be given a fine up to $10,000. Now, if a person is convicted of a capital murder, which is the highest offense, then the minimum is life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, you don't have to worry about those offenses or those type of punishment, because as I mentioned to you, your punishment, your case is not a felony. It's a misdemeanor. And misdemeanors are divided into 3 categories. Hey, most.
I'm about to go call Sarge.
Okay, now, misdemeanor cases again are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder. Well, you have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, with the class C misdemeanor, you cannot be given jail time. You only can be given a fine. And the fine cannot be above $500. Okay? Now, class C misdemeanors are cases that start in the city court or the JP court. They only come to this court when a person is found guilty, and then they appeal the case, and then the case comes up to this court. And then they get a whole new trial. The punishment range does not change. It's still fine only, and the fine cannot be above $500. Now, just an example of a class C misdemeanor would be speeding, or not having your seatbelt on, okay? Or let's say having an expired sticker. Those are class C misdemeanor. Now, the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days which is 6 months in the county jail. Or you could be given a fine up to $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a class A misdemeanor. And with the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail. Or you could be given a fine up to $4,000, or you could be given both jail time and a fine. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And the other type of probation is called adjudicated probation. Adjudicated probation. So you have unadjudicated probation and you have adjudicated probation. And the difference between the 2 is as follows. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete that probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. What a non-disclosure is, it basically means that your record will be sealed to the general public. So the general public cannot have access to your record. Now, the operative word that I used was general public. Now, there are certain governmental agencies that are listed in the Texas Code of Criminal Procedure that can have access to your criminal record. But most of the public is the general public, so they cannot have access to it. And let's say you had deferred adjudicated probation, and let's say you got a non-disclosure, and let's say you applied to a job at Holmes. Well, when Holmes will do a criminal background check, they won't see this case. Why? Because it's sealed to them. They're part of the general public. All right. Now, the next type of probation, as I mentioned to you earlier, is called adjudicated probation. With adjudicated probation, that means that it's the regular probation. You do have a conviction on your record. However, there is something that is called judicial clemency. And judicial clemency means that the court or the judge can set your conviction aside, which means you will no longer have a conviction. It's almost like a pardon. And so you will no longer have this conviction on your record. However, if you get another conviction later on, we call that a subsequent conviction, another conviction later on after you receive judicial clemency on this case, then what's going to happen is the case that you receive judicial clemency on is going to be resurrected, going to be brought back up. It's going to be revived, and then it can be used against you. And if you try to get a license, say with CPS, which is Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. Okay, now, everyone here today for a case should have a clipboard. And I'm getting ready to go over that clipboard with you. The first document on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. And the document looks like this. Okay? I'm going to go over this document and I will constantly refer back and forth to this document. All right. Now, this document states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Those are your 3 options. Now, the first sentence under number 3 states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. The next one sentence paragraph below number 3 states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard, and it looks like this. Is titled Jefferson County Affidavit of Indians. Now, this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to fill out this document, okay? Now, if you're applying for a court-appointed attorney, you would have to fill out the entire first page of this document. And then you go to the second page, and on the second page, at the top, you fill out the top portion that is titled Defendant's Oath. And then you fill out the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. All right. Now, going back to the first document, Judge's Explanation of Rights to Defendants Without Attorney, the next one sentence paragraph is for individuals who will be representing themselves. Okay? You have a right to represent yourself if you desire to do so. So now, if you represent yourself, you will be your own attorney. And just like an attorney can talk to the district attorney and assistant district attorney, that we call prosecutors, about your case, you can also talk to the prosecutor about your case. And we have one prosecutor in court this morning, his attorney, Samuel Masradian. He works for the Jefferson County District Attorney's Office. So if you represent yourself, you'll be able to talk to him about your case. And, but before you can talk to him about your case, you have to first fill out a document that is titled Waiver of Counsel. It's titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You would fill out this document if you are representing yourself. If you're hiring your own attorney, you don't have to fill out this document. If you are requesting a court-appointed attorney, you do not have to fill out this document. So only if you are representing yourself, you would have to fill out this document. And then you will have, once you fill out, read and fill out this document, or sign this document and date it, then you'll be able to talk to Mr. Masradian about your case. All right, now, this form, going back to Judge's Explanation of Rights to Defendants Without Attorney, this paragraph in block form, the second to the last paragraph, and that's for individuals who will be representing themselves. Say, be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself, may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you decide to represent yourself, this last one sentence paragraph down here states that you may change your mind at any time and request that an attorney be appointed to represent you. All right. So, let's say, you would like to represent yourself. And let's say you would like to see if the state is going to offer you a fine in this case. Okay. And let's say, okay, you represent yourself, talk to the attorney, district attorney, and the district attorney say, no, I'm not gonna offer you a fine, I'm gonna offer you jail time or probation or whatever. And you say, well, I don't want jail time, I want probation. So the document states that you can change your mind at any time and request that an attorney be appointed to represent you, or you can request time to hire your attorney. Okay. Now, At the bottom of this document, in bold letters, it states, defendant's choice. Mark your initial next to only one choice. Now, everyone here is going to make a choice. Okay, you're gonna make one choice. Now, if you would like to hire your own attorney, then you will place your initials on the first line to the left. All right? And then you'll sign the bottom of this form where it says defendant dated today's date, August 18th, 2026, and this will be the only form that you have to sign and you'll stop. All right. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left. Okay? The second line to the left, and the name of the attorney on the line to the right. Then you'll sign this document and date it today's date, and then you'll stop. This is on the form that you have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left, and then you'll sign and date the form, and then you'll fill out this document that is titled Jefferson County Affidavit of Interest. You would have to fill out the entire first page. Then you go to the second page, you're gonna fill out the top portion that is titled Defendant's Oath. And then you'll fill out the middle portion that's titled Unsworn Declaration by a Defendant, and then you'll stop. If you have already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left, the name of the attorney on the line to the right. You sign this form, date it, and stop, and this is the only form that you would have to sign. Now, if you would like to represent yourself, then you'll place your initials on this last line to the left. You put your initials there, then you sign where it says defendant, you date it, and then you'll fill out this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You read it, sign it, and date it, and stop. Okay. Do we have any questions? Okay, now, we're gonna give you time to fill out that paperwork. And if you need help with the paperwork, we have our core personnel who's here, including myself, who will be, helping you to fill out the paperwork if you need assistance. All right, now, you have a right to, enter a plea of either guilty. If you enter a plea of guilty, you tell the court that you committed the offense that you've been charged with. Or you can enter a plea of not guilty. If you enter a plea of not guilty, you tell the court that you did not commit the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Now, you have a right to have what is called a trial by jury. If you enter a plea of not guilty, you want to have a trial, you have a right to have a trial by jury. The area over there, we call that the jury box. There are 12 chairs, but in county court, you have a 6-member jury. And so 6 members from the Jefferson County area will be selected to serve as jurors in the case. They will listen to all the evidence that's presented by the state and by the defense. They'll be listening to the arguments of the state and the defense. And then they will go into the jury room to deliberate. And they can find you either not guilty or guilty. You also have a right to waive your right to have a trial by jury. Waiving your right to have a trial by jury means that you're giving up your right to have a trial by jury. And you still can have a trial, it just will not be a trial by jury. You can have what is called a bench trial. And what a bench trial is, it's a trial by judge. The judge will be the judge and the jury in the case. And the reason why they call it a bench trial is because the judge sits on the bench, so they call it a bench trial. And so, the judge will listen to all of the evidence that's presented by the state and by the defense. The judge will, hear the arguments of the state and the defense, and then the judge will apply the facts to the law and decide to find you either not guilty or guilty. Okay, now you can waive your right to have a trial by jury or trial by judge. In that case, you obviously enter a plea of guilty or no contest. And if you do that, then you have a right, you can enter into a plea bargain with the state. Now, what a plea bargain is just a way, it's a settlement. Y'all come to a settlement, the state makes an offer, let's say you wanted to see if you could get a fine, the state offer you a fine, you say, oh, I want to accept that. If that's agreed, we call that an agreed plea bargain. If you can't come to an agreement, we call it an unagreed. If you still want to go forward, you call it an unagreed plea bargain. And the difference between the two is as follows. With the agreed plea bargain agreement, it has to go before the judge, and the judge can do one of two things. The judge can accept or reject the agreement. Now, if the judge rejects the agreement, the law says that you can take your plea back or you can withdraw your plea. What that means or what it looks like is this. They offer a fine, you wanted a fine, it goes before the court. The court said, well, I'm not following a plea bargain agreement. And you say, well, judge, I'm taking my plea back, you're not following the agreement. I'm not going to enter a plea of guilty and no contest. You can do that. Now, if the judge follows the agreement, then within 30 days, you decide, you know what, I think I've been wrongfully convicted or the court committed an error by convicting me. I like to have a new trial, or I like to file an appeal. You have to get permission from the judge. And if the judge gives you permission, guess what? The case is gonna go right upstairs to the Ninth Court of Appeals. There are 4 justices up there. And what they're going to do, they can grant or deny your appeal. They're gonna review your case. And if they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court with orders. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. In fact, you can appeal it to the highest criminal court in the state of Texas, located in Austin, Texas. It's called the Texas Court of Criminal Appeals. Now, you have to file what is called a pro se petition for discretionary review. I'll explain it to you. Pro se means yourself, you don't have an attorney. You petition in the Texas Court of Criminal Appeals by yourself to review your case. Why? To see if your appeal should have been granted. Or to see if this court committed an error by convicting you. They can do one of two things. They can grant or deny your petition. If they grant your petition, guess what? They can simply find you not guilty and the case is over. Or they can send the case back up to the Ninth Court of Appeals with orders, or they can send it back down here with orders. All right. Now, if they deny your petition, then at that point, your conviction will stand. Now, you also have a right I mentioned to you, you can enter into an agreed plea bargain agreement, but there's an unagreed plea bargain. Let's say you don't like what the state is offering, but you want the judge to decide what your punishment will be. That's called an unagreed plea bargain. And then the judge will decide what your punishment will be in your case, anywhere within the punishment range. Now, that chair back there that has the microphone in front of it, we call it the witness stand. As a defendant of the criminal course in a criminal case, you have a right to call witnesses in your case. Now, they take the witness stand. Now they can testify for you, or they can testify against you. If you're representing yourself, you can ask them questions. Or if you have an attorney, your attorney can ask them questions. And we call it either direct examination or cross examination. Now, you can waive or give up the right to have witnesses. By waiving or giving up the right to have witnesses, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have a Fifth Amendment right against self-incrimination. I'll explain that to you. Fifth Amendment right against self-incrimination, what that means is, in the United States Constitution, the Fifth Amendment gives us the right to remain silent. What that means is this: the state, the district attorney's office, the government cannot force you to take the witness stand and testify against yourself. Because if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, it kind of looks like this. I know a lot of times we watch television and we see shows like Law and Order, and we see the television lawyer walks up to the witness stand and asks the witness a question. The witness says, "I take the fifth." But that means is, I'm not saying nothing. You can't make me say nothing, because I'm exercising my Fifth Amendment right against self-incrimination. Now, you can waive it, which means you can give it up. And if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be taking the witness stand. Now, you also have a right to have what is called discovery. And what discovery is, you have a right to see the evidence that the state has against you in its file. You have a right to see your statements, witness statements, police reports, lab reports, videos, video recordings. You have a right to see those. You have a right to see photos. You have a right to listen to audio recordings. You have a right to have access to any type of instruments that they have. For example, if there's a gun in the case, you have a right to have access to that, or any type of documents that they have. You have a right to have access to that. Now, you can waive or give up your right to discovery. If you waive or give up your right to discovery, what that means is you will not be having access to it, because you do not want to have access to it. Okay. Now, everyone that's here today for a case, charges have been filed against you. You've been arrested. You've been placed in a county jail, and you bonded out. Every day that you spent in jail can be used as credit toward your punishment. So, for example, now the operative word that I said is every day. Let's say you were booked in the jail at 11:59 p.m. last night. And let's say you booked out of jail at 12:01 a.m., 2 minutes later. Guess what? That's 2 days. The reason why it's 2 days credit is because yesterday was Monday, 11:59, and 12:01 was Tuesday. 12:01, that's 2 different days. So you get 2 days credit. And so I said that to say this: every day that you spent in jail can be used as credit towards your offense. So let's say you spent 5 days in jail. And let's say you talk to the state is offering you 5 days in jail. That means you don't have to do no more time in jail, because you already spent 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering you 7 days and you spent 5 days in jail, that means you only have to spend 2 days in jail. Why? You have 5. You just have to subtract 5 from the 7 and leave 2. Now, every day that you spent in jail also could be used as credit towards your fine and court costs. For every 1 day that you spend in jail, you're credited $100 per day. So if you spent 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, guess what? You don't have to pay anything. Why? because the 5 days that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if the state is offering fine and court costs of $700, you spent 5 days in jail, which is $500. That means you would have to pay $200 because you already have $500 that we will subtract from the $700, and that leaves $200. Now, you'll be required to pay the $200 on the day that your case is taken care of. If you cannot pay it, guess what? No problem, because we can put you on a payment plan. And you can pay it off in small monthly installments until it's paid off. Now, let's say you don't have the income to be put on a payment plan. Not working, you do not have income. No problem. Because we can convert the fine and court costs to community service. And so for every 1 hour of community service that you perform in a nonprofit organization in Jefferson County, $12.50 will be credited toward the payment of your fine and court costs. So what does that look like? It looks like this. If you work 8 hours, 1 day, that's $100. So you work 2 8-hour days, that's $200. And guess what? Your fine and court costs is paid off. The balance. Okay. Now, Jefferson County has a program. Let's say you haven't been in trouble before, you first time having 1 or more cases filed against you. Well, the district attorney's office in Jefferson County has a program that is called pretrial diversion. And with pretrial diversion, what they will do, they will dismiss your case once you complete the program. And you can get it wiped off your record like it never happened. That's called expunction. Okay, now in order to qualify for the program, 3 things has to happen. 1, it has to be your first time getting 1 or more cases. 2, you have to have a lawyer to assist you with the application process. The lawyer could be appointed. It doesn't have to be hired. And 3, it cannot be a foreign offense involving lawfully carrying a weapon or resisting arrest. Now, if you fall in a category, you can get into the program. You get into the program, they will dismiss your case, and you can get it expunged or wiped off from your record. And what an expulsion looks like is this. Let's say this is your record of your case. Okay, when somebody do a criminal background check, they can see all this information. When they do an expulsion, it looks like this. Okay? When they go and look, it's nothing there. Like it never happened. Okay. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program called Veterans Court. It is a program for veterans only. The only thing you have to do to get in the program is to be a veteran of any one of the branches of the United States military. And with that program, once you complete the program, they'll dismiss your case and you can get that expunged from your record as well. Now, this court, County Court Law Number 2 of Jefferson County, Texas, has a program that God led me to start. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. Recidivism is when people commit crimes over and over and over. And so the way we address recidivism is through partnerships that we have with various agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center in the Jefferson County, in the Southeast Texas region. And with Spindletop, Spindletop has the expertise to address any mental health issue that you have. You do not have to be incompetent or insane to participate in the program. You can merely suffer from depression or anxiety or any other host of mental illnesses. And they have doctors, counselors, mental health officers, and a whole host of other employees that can help to address your issue. Now, and what Spindletop normally do, they come in here on Tuesdays, and what they normally do They will do a private interview either in our jury room at their facility by telephone or by text, whichever is convenient for you. Then they will do an assessment. An assessment is they will determine what the mental health issue is. And then once they determine what the mental health issue is, they will develop a treatment plan to address the mental health issue. It could be either by inpatient or outpatient services. Now, if you have issues with drugs and alcohol, well, Spinotop has another program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council, and they have a drug recovery program that is called OZAR. OZAR is an acronym, OSAR, that stands for Outreach Screening Assessment and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a screening, which is an interview, an assessment to determine what the drug and alcohol issue is, and then they can develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. That's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you are trained in any one of those areas that you select, they will help you to get a job in an area that you're trained in. And what does that look like? Well, it looks like this. Let's say you already have training, and let's say you went to get a job at ExxonMobil, you don't get the job. And let's say you went through CICE, they go to Mobile on your behalf, you get the job. Okay? Because they have a proven program that these companies look at. And they can get your foot in the door, or it can open doors that you couldn't get in. Okay, so that's the beauty of that program. Now, if you have not graduated from high school, or if you do not have a GED program, well, CICE as well as Spinotop has a GED program, where you could get your graduate equivalent diploma, GED. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this quote, we don't just give time, we take out time. And that means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual courts. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. Why? Because what comes out in the home goes into the community. And so if you're interested in any one of these programs that I just mentioned to you, just let us know. And we can direct you to the people that you need to talk to so that you can get on the road to living your best life. Now, the paperwork that you have, we're going to pick that paperwork up from you. We have our court personnel. We're going to put you into one of three categories. One, you want to hire your attorney. And if you want to hire your attorney, your case will be reset today. Two, if you would like to apply for a court-appointed attorney, if you qualify, your attorney will be appointed today before you leave. And three, if you would like to represent yourself, and if you are able to work out a people agreement with the state, your case will be taken care of today before you leave. All right. Now, be mindful that we're still in court because we'll be going to a break. If you need to use the restroom, there are two restrooms right out in the hall. we have the mid restroom in front of county court on the three, and the wood restroom in front of county court at law number in front of the 172nd district court, which is on the other side of the hall. Yes,
If you want to represent yourself, then you would hit that today.
here's your case, we taking care of that.
Does
Yeah. Yeah, you would have to initial the bottom where it
Yeah, I
says,
had it for a court appointed
Right,
attorney.
yeah.
My brother just talked to
okay, well, you can just change that, scratch through that and put that in there. And then you're going, sir, you have to do the quiet. Okay, so you're gonna get initial there, scratch through that one, and then you're gonna fill out that form that's titled waiver of counsel for purposes of interviewing. Just turn to that. Yes, probably the last one. That's all you got on it. Let me see. Ah, listen. Well, that's just out of order. Yes, oh, you already got to fill out. All right, you already got to fill out. Yeah, that's it. That's it. That's all you need to do. Okay, and we're gonna call you up. Be mindful that we're gonna be having a recess. We're still in court. So conduct yourself accordingly. Again, I forgot to mention that on that first page where it says state of Texas versus at the top left hand corner, there's a line, please print your name. And the reason why I say print your name is because if your handwriting is like mine, sometimes I can't read it. Okay, so you print your name so we'll be able to match up the person with the paper. All right? All right, so we get ready to go into recess and make sure that all your paperwork is filled out, and we're gonna put the coordinators, they're gonna tell you to come up, and then they're gonna check your paperwork to make sure it's filled out properly, and then we'll go from there. Okay, so the court is in recess.
You are done with your paperwork?
Jefferson County Court at Law number 2 is in session. The court is in session with its jail review docket. First case is clause number 24 CCCR 0654. Case is styled the state of Texas versus Tijuan Mack. Mr. Mack, is that your full name?
Yes, sir.
Mr. Mack, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Mack, you may put your hand down. And again, Mr. Mack, how are you doing?
I'm doing good. How you doing?
I'm doing fine. Thanks for asking, Mr. Mack. The attorney of record is Attorney Bruce Smith. Attorney Bruce Smith is not here today. However, standing in for Attorney Smith is Attorney Julie Shipley. Does Ms. Shipley have your permission to stand in for Attorney Smith?
Yes, sir.
And Ms. Shipley, how are you doing?
I'm fine, thank you, Judge.
That's good. Attorney Shipley, do you waive a record in Mr. Mack's case?
We do.
Now, the state is represented in this case by Attorney Samuel Masradian. And Attorney Masradian, how are you doing?
Doing well, Your Honor. Thank you.
That's good. Now, Mr. Mack, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Tijuan Mack, on or about December 20th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Mr. Mack, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Mack, how do you plead? Guilty, not guilty, no contest?
No conflict.
Now, okay, your initials are on the line next to the box that's checked guilty.
I'm guilty then.
Are you pleading guilty?
Yes, sir.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Mack, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, TM on the line next to the box that's checked guilty. Do you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of the Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there's one box checked. The box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Yeah, the discovery certification.
Put it up there.
Oh, here it is. Now, Mr. Mack, I also have before me on the paper a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defender?
Yes, sir.
Now, Mr. Mack, before you sign and initial all these documents that I just showed you, your attorney go over these documents with you.
Yes, sir.
And did you understand everything that she went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Mack, are you a citizen of the United States?
Yes, sir.
State offers State's Exhibit 1, Your Honor.
Any objections to States one? No objections, States Exhibit Number 1 will be admitted. And Attorney Shipley, you advised and counsel Mr. Mack, is there any evidence that he's currently mentally incompetent to stand trial?
There is no evidence of that.
Okay, and Mr. Mack, your attorney, Ms. Shipley, has advised and counseled you. Are you satisfied with her services?
Yes, sir.
And Attorney Bruce Smith has also advised and counseled you. Are you satisfied with his services?
Yes, sir.
Okay, Mr. Mack, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That'd be confinement in the county jail for 186 days with credit for 186 days time served. Is that right?
Just say 185.
That's what I meant. Yes, Your Honor. 185, all these numbers. And this is to run concurrent with the 2 felony cases whose cause numbers escape me right now, but they're written on the plea agreement.
Okay, let's see. Okay. Okay, Mr. Matt, the state is offering that you serve 185 days in the Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail because you've already served 185 days in Jefferson County Jail on this case. The court costs in this case will be taxed and retired. What that means is, it means that the time that you spent in jail has already paid off the court costs, so the court costs will be taxed and retired. This case will run concurrent with cause numbers 24 DCCR 1046 and cause number 26 DCCR 0085. Mr. Matt, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Mack, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Mack, you're going to follow the directions of the bailiff. And once you finish following the directions of the bailiff, you can follow the bailiff and you have a blessed day.
All right, you too.
Okay.
This is true.
First case is cause number 26CCCR 0562. Case is style of state of Texas versus Sydney Aaron Williams.
Right there, you can stand right here in the front. Okay.
Ms. Williams, your full name is Sydney Aaron Williams.
Yes, sir.
Ms. Williams, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Williams, you may put your hands down. How are you doing, Ms. Williams?
I'm good, how are you?
I'm doing fine, thanks for asking. Ms. Williams, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes,
And
sir.
are these your initials on the line that state you have like to have your case reset to hire your own attorney?
Yes.
Ms. Williams, before you sign this document, did you read the document?
Hmm?
Did you understand what you read?
Sir.
Is everything in this document true and correct to the best of your knowledge?
Yes.
Ms. Williams, your case will be reset to give you an opportunity to hire your own attorney. You get your reset from our court coordinator. Once you get your reset, you're free to go,
Okay,
and you have a blessed day.
thank you.
You're welcome.
Thank you. Thank you.
Logan Andre Oderbert. Mr. Oderbert, your full name is Logan Andre Oderbert. Mr. Oderbert, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Oderbert, you may put your hand down. How are you doing, Mr. Oderbert? I'm doing fine, thanks for asking, Mr. Oderbert. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Mhm.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to apply for court appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Mr. Oderbert, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Oderbert, I read your answers. Based on your answers, if you meet the eligibility requirements for the appointment of court-appointed attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Mr. Lawrence will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. All right. Jamie Milo. Okay. Okay, she's not in here.
Step out of the restroom. You can go.
Nakia Riley. Miss Riley, your full name is Nakia Lee Riley.
Yes, sir.
Miss Riley, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Miss Riley, you may put your hand down. How are you doing, Miss Riley? You doing okay? That's good. Now, Miss Riley, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit. Hold on, let me write this number on here. I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defender Signature. Is this your signature?
Yes, sir.
Now, Ms. Riley, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Ms. Riley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information, you're free to go and you have a blessed day.
You too.
Stand in front of the court coordinator. Okay, Jamie Milo. Okay, Ms. Milo, let's see.
Have a recess. To Judge Stevens.
Okay, it's on the same date. Okay. Okay, Ms. Milo, your full name is Jamie Trinell Milo.
Yes, sir.
Ms. Milo, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Ms. Milo, you may put your hand down. How are you doing, Ms. Milo?
I'm doing well. Thank you, sir.
That's good. Now, Ms. Milo, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir, it is.
Okay, Ms. Milo, before you sign and initial these documents, did you read the documents?
Yes, sir. it
Did you
is.
understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, it is.
Okay, Ms. Milo, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go,
Yes,
and you have a blessed day.
God bless you. Thank you, sir.
All right, thank you.
I'm sorry, what was the?
Marcus Wilkerson.
You could just send the first name.
Reagan Cox. Mr. Cox, your full name is Reagan. Let's see. Reagan Cox.
Yes, sir.
Okay, Mr. Cox, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Cox, you may put your hand down. How are you doing, Mr. Cox?
Good, how are you?
I'm doing fine, thanks for asking. Mr. Cox, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to
Yes, sir.
apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
Mr. Cox, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Cox, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, but before she gives you that information, the bailiff is going to give you some bond conditions. And the document that you have before you is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over these bond conditions with you. And it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other locations frequented by the alleged victim. Do you understand that condition? And condition number 4 does not apply. That only applies in a DWI case. Your case is not a DWI case. However, condition number 5 does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that condition?
Yes, sir.
And now condition number 7 does apply, and it states that the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail.
Question for you.
Yes,
Is that permanent or is that just for?
while you're on bond. Okay,
Yes, sir.
so, Mr. Cox, just have a seat, well, stand in front of the court coordinator and wait for your name to be called. Once your name is called,
You have a seat, have a seat.
have a seat, okay. And once you finish with the court coordinator, you're free to go and you have a blessed day. And she's gonna give you, information on where you can get the, GPS. Philip Neal. Okay. Okay, Mr. Neal, you come forward. Okay, Mr. Neal, your full name is Philip Neal.
Yeah,
Ms. Neal, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
that's what.
Mr. Neal, you may put your hand down. How are you doing, Mr. Neal?
So,
How are you doing?
how old am I?
How are you doing?
Oh, I could be better. This stuff got me,
Okay. It could be worse too.
I don't know, I never been in trouble before.
Okay, well,
What has got, like, turned my life upside down?
okay. Now, Mr. Neal, did I swear you in? Okay, swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay. Now, Mr. Neal, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Okay,
Do you recognize it?
yes,
Is this your signature on the line that's titled Defendant?
yes,
Are these your initials on a line that state you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes,
Now, Mr. Niels, before you sign and initial these documents, did you read the documents? And did you understand what you read?
well, did I read them?
Yes. Did you read them before you
read it.
filled it out and signed it?
Why not, every word on it, I just was. Right.
Yeah, but you
sign-
had to read it before you signed it. It asked you for your name. And you put Philip Lewis Neal.
Yes,
You read that?
yes,
It asks you for your date of birth. You put that down.
yes,
It asks you for your address. You put that down. Is that
Yeah.
correct? And then it says defendant's signature. You put your signature on there. Is that correct?
yes,
It asks you for the date. It puts the date on there. Okay, now you also had someone to help you with this document. Is that correct?
yes,
Okay, and did you understand everything that they went over? Now, is everything in this document true and correct to the best of your knowledge? It's true? Okay, now, Mr. Neal, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to give you a document that is titled Standard Bond Conditions. I'm going to go over these bond conditions with you. You see that document? Do you see that document that you have before you? Okay, now,
bond conditions,
yes, it states, following the return of a criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein, which is you, Philip Neal, hereinafter are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. You understand that condition? Okay. And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
so that's not, the protective order not still in effect.
That the protective order is in effect, but now you have some bond conditions in this court.
Yeah.
Protective order is
Last
in a,
night, my wife called me because some animal had got into the
well,
house.
Mr. Neal, let me tell you this here. You have a right against self-incrimination, a Fifth Amendment right against self-incrimination. First of all, you have a right to have an attorney. If you cannot afford to have an attorney will be appointed to represent you, and that's what this is. Now, anything that you say can and will be used against you in the court of law. Do you understand that? So you have a right to remain silent. All right. Now, do you understand that you shall not communicate either directly or indirectly with the alleged victim of the pending offense, and you shall not go near any residence, school, or other location frequented by the alleged victim? Do you understand that? Okay. Now, on the next page, condition number 5 states that You are prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 7, the defendant shall wear a global positioning monitoring system, which is a GPS device, at the defendant's expense with written verification being submitted to the court
But
within 3 days.
I can't afford that. How
Well,
much is it?
well, you said you can't afford it, you don't even know the price.
Cost my rent, I only
Okay.
get $1,000 a month.
Okay, well, you didn't put that on there. I'm looking at an amount that you put in there was well above what you just said.
Huh?
Now, I'm looking at what you put on here, on your affidavit of indigence. I'm not going to state that amount, but it's well above what you just said, okay?
Well, besides the other things that I have to spend.
Okay, I'm looking at your expenses and I'm looking at what's left over,
Well,
okay?
I haven't even got my first month light bill.
All right,
I don't even know what
okay.
my light, I just moved in
Okay.
August the 3rd.
So that simply means that you have income.
Sorry?
It means that you have income because you hadn't paid no bills. Okay, but Mr. Neal,
My light bill.
Mr. Neal, let me tell you this here. I read the police report. I read the probable cause affidavit. Okay? And based on that, the court is ordering that you get a GPS. All right? So our court coordinator is going to give you places you can get it from. There are some places that'll be able to work with you. They can contact the court and tell the court about your financial situation, and then something can be worked out. But you have to get a GPS. All right? So you're gonna get your reset. Once you get your reset, you're free to go and you have a blessed day. Please stand in front of the court coordinator.
How long would it be before I go to trial? Cause I would like to you're just behind me. I don't know how fast this works.
Well, you talk to your attorney about that. Okay, your attorney can give you all of that information. All right?
Sure.
Hey, you're gonna sit right there. Mr.
Neal.
Mr. Neal,
Oh, look.
you're gonna sit in that chair. Okay, once you finish there, then you can go talk to him.
Your attorney's name is Charles Hall.
Yeah.
This is your next court date.
Mr. Coleman?
Okay.
Okay, now, Mr. Coleman, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Okay, you may put your hand down. How are you doing?
Okay.
Okay, and, Mr. Coleman, I have before me. Well, I need to see a copy. Brilliant. Yeah. Okay, now, Mr. Coleman, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature? Now, Mr. Coleman, before you sign and initial these documents, did your attorney, did you read the document?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct? Or true and correct to the best of your knowledge? Mr. Coleman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. But once she gives you that information, you'll be free to go and you have a blessed day. Now, before she gives you that information, I need to give you some bond conditions. Okay, now, Mr. Coleman, the document that the bailiff just handed to you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes, sir.
Okay, I'm going to go over this document, which it states that following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or orders subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Sure.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, on the next page, condition number 5 and 7 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 3, the defendant should wear a global positioning monitor system, which is a GPS device, at the defendant's expense with written verifications being submitted to the court within 3 days. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked, and you'll be arrested and you're placed in the Jefferson County Jail. Do you understand? Okay, now, Mr. Coleman, you'll get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day. Wait a minute, please. Let's see. Let's see, is that? Oh, I don't see somebody named Rogers. Brandon,
That's what
I was looking for his,
That's Rogers.
is this, oh, here it is, Brandon Aldrich Rogers. Brandon Aldridge.
Sir.
Gary. Okay. That's your next call, then. We should be contacting you at the number you gave. If you have any questions, you want to call. With, giving this call. You gotta give them all the things, right here.
Okay, Mr. Rogers, your full name is Brandon Aldridge Rogers.
Brandon Allen Aldridge Rogers, yes, sir.
Okay. Mr. Rogers, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Rogers, you may put your hand down. How are you doing, Mr. Rogers?
Living the dream.
Okay, that's good. Now, Mr. Rogers,
That door is locked, Gary. That door is locked. Okay.
the state is represented in this case. Well, first of all, Mr. Rogers, before we go any further, you have a right to have a court reporter to dictate everything that's being said in this proceeding. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay, Mr. Rogers, the state is represented in this case by Attorney Samuel Masradian
Yes, sir.
and Attorney Masradian. How are you doing?
Doing well, Judge. Thank you.
That's good. Now, Mr. Rogers,
Yes, sir.
on my computer, I have a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brandon Aldridge Rogers, on or about February 18th of 2026, while you are operating a motor vehicle in a public place in Jefferson County, Texas, it alleges that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Rogers, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Rogers, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Rogers, I also have before me a document on my tablet that's titled Misdemeanor Plea Admonishment. Do you recognize this document?
Sir.
On page 2 of this same document, there are two sets of initials. First set of initials are on a line next to a box that says guilty. Did you place your initials here?
Yes, sir.
Second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discover in this case and choose to enter the plea of guilty, no contest.
Yes, sir.
You place your initials in the second location as well.
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
defendant? At the top of this document, there are two boxes checked. The first box is checked, states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Rogers, I also have two documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea
Yes, sir.
Proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Sir.
Mr. Rogers, before you sign and initial all of these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Rogers, are you a citizen of the United States?
Yes, sir.
State offers States Exhibit 1, Your Honor.
Mr. Rogers, the state is offering States Exhibit number 1 to be used as evidence against you in your case. States Exhibit number 1 is the first document that I showed you on this tablet.
Yes, sir.
It is the same document that has your initials in these two locations on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objections. States Exhibit number one will be admitted. Mr. Rogers, is there any evidence that you are currently mentally incompetent to stand trial?
Perfectly competent.
Okay, Mr. Rogers, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt.
Sir,
State, do we have? Are you waiving the enhancement paragraph? Because you got deferred, you can't get deferred in class A DWI. unless
Yes, we'll waive the
enhanced.
enhancement paragraph, Your Honor.
Okay, so you should have to do, okay. Wait on, you can write that on there.
I'm gonna scratch down on that other page too, Your Honor.
Okay, now, Mr. Rogers, I'm gonna go back to the information. This information alleges that you, Brandon Aldrich Rogers, on or about February 18th, 2026, while you were in Jefferson County, Texas, that you committed the class A misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place, and you had a blood alcohol concentration level of 0.15 or more. Now, that's a class A misdemeanor.
sir.
The state is abandoning an enhancement paragraph, which means you'll be charged with a lesser included class B misdemeanor. Do you understand that?
Included, so.
No, it's a lesser, when they use the word included, because they're going to get rid of the
Point-
class A, the 0.15, and you'll just be charged with a DWI first. Do you understand that?
Yes, sir.
Now, the range of punishment is, you gotta
Yeah,
change
yeah.
that too. The range of punishment changes as well. It's reduced, so it will go to a class A, a class B misdemeanor DWI, which has a minimum of 72 hours to a maximum of 180 days in jail, as opposed to 365 days in jail if it was a class A.
Yes, sir.
Now, also, the fine, the maximum fine for a class B is $2,000.
Yes, sir.
If it was a class A, it would be $4,000.
Yes, sir.
Okay. And you could be given both such fine and confinement. Do you understand that?
Yes, sir.
All right. Now, and to this class B misdemeanor offense, DWI, how do you plead? Guilty, not guilty, no contest?
Guilty.
Guilty, okay. All right, now, going back to the punishment. Okay, now state, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
The state would be asking the court to defer adjudication on this matter for 16 months, to impose a fine of $400, as well as 36 hours of community service, and require that Mr. Rogers install an interlock device on any vehicle he owns or operates, as well as impose DWI standard terms and conditions. At this point in time, Mr. Rogers does not have a license and is not driving a vehicle. He anticipates getting one back in a couple, was it weeks,
Or like
months?
September 13th.
Next month. So
Right.
won't be installing that until then.
Yes, sir.
Give
Well, I
us
think it's the
a
18th, actually.
give us a-
It's supposed to be a 6 months since
387.
after the violation,
Gotcha.
so September 18th.
Okay, Mr. Rogers, the state is offering that you serve is that, I was trying to read that. Is that 16?
Yes, Your Honor.
Okay. Hold on a minute. Okay. Mr. Rogers, the state is offering that you serve 16 months deferred adjudicated probation. During the 16-month probationary period, you'll be required to pay a fine of $400 plus court costs of $387. You'll also be required to pay DWI conviction fine fee of $100. You're required to pay probation fee of $60 a month. You're not to pay $15 a month reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $140 a month. Will you be able to pay the $140 each month?
Yes, sir.
You'll also be required to perform 36 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You will also be required to attend a completely DW education class, have an alcohol assessment, and follow all the terms and conditions of your probation. You will be, now, Mr. Rogers,
Yes, sir.
do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Rogers, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Rogers, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. And you can talk to an attorney about the non-disclosure,
Yes, sir.
okay? You're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
Done.
Zoe Cormier. Or Cormier. Okay. How are you doing, Miss, do you pronounce it Cormier or Cormier? Cormier? Okay. How are you doing, Miss Cormier? I'm doing fine, thanks for asking. I'm Miss Cormier. I have before me first I'm gonna do this here. I have before me two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And did I swear you in? Well, you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, you may put your hand up. Now, Ms. Cormier, before we go any further, you have a right to have a record made of this proceeding. That is, you have a right to have a court reporter dictate or type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you understand that? Now, do you waive or give up the right to have a court reporter? You want a court reporter?
I need one, or like not really, right? Can you answer that for me? No.
Nah, it's your choice.
Oh, then I don't know. No, sorry.
Okay, now, Ms. Cormier, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Now, Ms. Cormier, before you sign and initial these documents, did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Cormier, I have before me a document that has been filed by the Jefferson County District Attorney's Office. And this document is titled Motion to Dismiss. Is that correct, State?
That's correct, Your Honor.
Okay, Ms. Cormier, I'm signing the motion to dismiss this case. Okay, Ms. Cormier, your case has been dismissed. You can get a copy of the dismissal from our court coordinator. Once you get a copy of this dismissal, you're free to go and you have a blessed day.
Ms.
You are-
Cormier was also interested in programs regarding the GED, the CI, what was it called? CI.
Yeah, CE,
Where could she find more information about that?
she has that brochure. That brochure is being handed. Is that your mom? Okay, thanks for coming out here with your daughter. And Ms. Cormier, before you leave, how old are you? 18. I used to be 18 for 360. You're 19?
Yes.
I used to be 19 for 365 days. Okay. And when I was 19, I had friends, and I'm sure you have friends. And in my day, well, in your day, you call your friends your BFF or your ride or die. Okay. In my day, we used to call them our ace boon coon. Those are individuals that we figured will be with us through thick and thin. When we're down, they'll be down there to pick us up. But on days like today, when you're in court, you're down and out. I don't see your ride or die, your BFF. But I do see that young lady back there with you. Who is that? Your mom. Okay, thanks for coming down here with you. You know why she's down here? Why?
She cares about?
She cares about you. She don't just care about you, she loves you. Okay, now your friends, these people you call your BFF or your ride or die, they not down here with you. You know why? They had something better to do. But there was nothing else in this world that could keep that woman that you call mom from being out here today. That's because she loves you. Let me tell you this here. Everybody is not your friend. Everybody is not your partner. But when that lady says she got you, she got you. Okay? And that's because she loves you. You know, I know you're 19. This is not the best day in your mom's life, and it's probably not the best day in your life. You're probably thinking, oh man, I'm in a whole bunch of trouble. My life is in shambles. I'm in a storm. Well, guess what? When you're walking through a storm, hold your head high. Don't be afraid of the dark. And at the end of the storm, there's a golden sky and a sweet silver song of the law. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you never walk alone. There's one thing about hope. You know what? Hope floats. And so when you drowning in the sea of confusion and you don't know what to do, hang on to that hope. May to keep your head above water. Okay? Now you can put all of this behind you. Some people might look at this here as a stumbling block, but you could look at it as a stepping stone. And you know what people use stepping stones for? They use stepping stones to reach higher heights. So you can reach any goal that you have, you want to accomplish in life. This would not prevent you from doing that. And when you reach for those goals, reach for the moon, shoot for the moon, because if you miss, you're going to be amongst stars. All right. And so you have a blessed day. And thanks for your grandfather and your mother. Thanks for coming down here with her. And I tell people this, I tell young people that come down here for support, you blessed. You have somebody here to support you, not just one person. You have two people here to support you. A lot of people come here, they don't have nobody to support them, but you blessed. And before the day is out, you need to give that man and that woman a big hug and a kiss for being out here to support you. All right. And I do know just on your mom, she was probably the woman and they probably was the persons that had to put a roof over your head, food on the table, clothes on your back, and every now and then, I'm sure they had to put a little spanking on your butt. They did all of those things because they love you. Okay. So you have a blessed day and just continue to reach for any goals that you have in life and you will accomplish it. All right. You have a blessed day. And thanks for coming out here with her. Don't hang up on her. Just stay with her. Hang on. Don't hang up. All right. You can get your dismissal. You're free to go and you have a blessed day.
Yeah, that was, Giovanni on page 2 of the book.
Okay. This is next Brian Davis. Mr. Davis, how are you doing? All right, Mr. Davis, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? You may put your hand down. Mr. Davis, I have before me two cases. There are cause numbers 26CCCR 1816 and cause number 26CCCR 1766. Both cases are styled the state of Texas versus Brian K. Davis Jr. And Mr. Davis, I have before me two documents on paper. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Yes. And is this your signature on the line that's titled Defendant? And are these your initials on the line that's titled, that states, I waive my right to an attorney and I desire to represent myself. Okay? And I have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding in Trial. You recognize this document? And is this your signature on the line that's titled Defendant? It is? Okay. Now, in cause number 26CCCR 1816, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brian K. Davis Jr., on or about February 6th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of dangerous drugs. Mr. Davis, do you understand what you have been charged with? To this charge, Mr. Davis, how do you plead? Guilty, not guilty, or no contest? Guilty. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. Davis, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. You recognize this document? And before I go any further now, Mr. Davis, I forgot to mention you have a right to have a court reporter to dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Court reporter is a person that type down everything that's being said. You waive it. Okay. Now, Mr. Davis, I also have another document that is titled, well, this on page 2 of the same docket, judge's explanation of rights to defendants without attorney. Oh, actually, the misdemeanor plea admonishment. On page 2, there are 2 sets of initials. First set of initials on the line next to a box that's checked guilty. Did you place your initials here? Second set of initials are on the line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document, there's titled trial court certification of defendant's right of appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement? Second box that's checked states that you're waiving your right to the appeal, which means you're giving up your right to the appeal. Do you understand that statement? Now, Mr. Davis, before you signed and initialed all of the documents that I showed you, did you read the documents? Did you go over the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Davis, are you a citizen of the United States?
State offer States Exhibit 1, Your Honor.
Now, Mr. Davis, the state is offering States Exhibit number 1 to be used as evidence against you in this case. States Exhibit number 1 is the first document that I showed you on the tablet. It's this document. And this is the same document that has your initials on the line in these 2 locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence against you in this case? Okay, no objections. State's Exhibit number 1 will be admitted. And Mr. Davis, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Davis, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
That'd be 90 days in county jail, probated for a period of 1 year, with a $300 fine and 24 hours of community service, as well as Mr. Davis needs to complete a drug assessment. In exchange for Mr. Davis's pleading in this case and his agreement to forfeit the weapon and the companion case, the state will be dismissing the companion case, cause number 26 CCCR 1766.
What's the court cost? Okay, Mr. Davis, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments is $136 a month. Will you be able to pay the $136 each month? You will. You will also be required to perform 24 hours of community service, have a drug assessment, and follow the recommendations and conditions and the terms and conditions of this probation. Now, the state will be dismissing your companion case, clause number 26 CCCR.
Can I
One-
confirm something, Your Honor? You have a job, right? Okay, so how are you planning on paying the 130 something a month? Is it you for sure that they're gonna be able to pay? Because
Let me
if you
ask you-
can't do it, it's okay. We're not gonna take away the plea. We'll convert it.
But does he have any time, do you spend any time in jail?
2 days.
Okay, we can give him some credit on that. His name is Brian K. Davis Jr. That'll reduce it.
I hate for you to agree to this and then you don't pay and then we have to do an MTRP. It's just not. We can find a way to not have it happen.
He got 2, so we're gonna give him 2 days credit. And let me do this here. That'll knock off that. That'd be 77. Okay, let me. Let's see this here. Okay, that'd be 118. No, are you able to pay now, we gave you that 2 days credit, so it's $118 a month. Are you able to pay $118 a month? I'm just asking, yes or no? You are? You just nodding your head, you have to say yes or no.
Yes.
Okay. Now, let's see. Now, as I mentioned to you earlier, the state will be dismissing the companion case clause number 26 CCCR 1766 for forfeiture of weapon in that case. And in that case, I have a motion to forfeit. Do you recognize this document? And did you read the document before you signed it? And did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Davis. I'll grant the motion to forfeit the weapon in this case. I'm signing the order. Now, Mr. Davis, do you understand the state's offer? And do you accept the state's offer? Mr. Davis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Davis, you'll stand next in front of the coordinator. Find her directions. Once you follow her directions, you'll be free to go. You have a blessed day. And you'll get a copy of the dismissal as well.
Well, what I'm asking is, do you want to speak to me about non-qualification?
Right, that's right.
You said you want to represent yourself on.
Sorry. Oh,
On this sheet, correct? Right. Are you saying that you want to say that you guilty or not accomplice, or are you saying? Okay, so then you want to, essentially you want this to be.
Raul Ortiz Estrada.
That's not what today's for. Uh, That can be, that can be discussed with the.
Good afternoon, Your Honor.
Good afternoon. Let's see, Estrada.
What we'll do is, we'll get this case, if you,
Ortiz
so you want
Estrada.
to continue.
Okay, Mr. Paul Ortiz Estrada, is that your full name?
So,
Roll.
Raul?
Yeah, you said.
Raul? I say Paul, okay. Raul, Mr. Estrada, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You may put your hand down and get, how are you doing?
Doing good.
That's good.
How
Now,
about yourself?
I'm doing fine. Now, Mr. Ortiz Estrada, before we go any further, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
This is just an initial.
Yes, I guess.
Okay.
This is just an initial hearing.
Now, Mr. Let's see, where is it? Okay, Estrada, Ortiz Estrada. Okay, here we go. Okay, Mr. Ortiz Estrada, I have before me. There's some paperwork here. I didn't see his paperwork. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled Defendant?
Yes, Your
Are
Honor.
these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, Your Honor.
I also have another document that is titled Waiver of Counsel for Purpose of Enter Guilty Plea or Proceeding to Trial. You recognize this document? He did
Yes, sir.
sign this.
Sign and acknowledge the above.
Okay, now, Mr. Estrada, is this your next, did you sign this document above the
Yes,
line that's titled Defendant?
yes, Your Honor.
Okay, Mr. Estrada, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Raul Ortiz Estrada, on or about February 14th of 2026, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, how did you plead? Guilty, not guilty, no contest?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, Mr. Ortiz Estrada, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's 2 sets of initials. One set is on the line next to the box that says check guilty. You place your initials in this first location.
Yes, Your Honor.
And in the second location, there's an initial on the line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case. And did you place your initials in the second location?
Yes, Your Honor.
On the next page, page 3, is a signature above the line that's titled Defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled Trial Certification of the Defendant's Right of Appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled Defendant?
Yes, Your
At the
Honor.
top of this document, there are 2 boxes checked. The first box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, Your Honor.
Second box says check, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, yes, Your Honor.
And before you signed all of the documents that I showed you, did you read the documents?
Yes,
And did you understand what you read?
yes,
And is everything in these documents true and correct to the best of your knowledge?
yes, Your Honor.
And Mr. Ortiz Estrada, are you a citizen of the United States?
Yes, Your Honor.
State up for State's Exhibit 1, Your Honor.
Mr. Ortiz Estrada, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on my tablet. This is the same document that has your initials on page 2. and your signature on page 3.
Yes,
Is it all right for the state to use this document as evidence in your case?
yes, Your Honor.
Mr. Estrada? State's exhibit number 1 will be admitted. Now, Mr. Estrada, is there any evidence that you are currently mentally incompetent to stand trial?
No, Your Honor.
Okay, Mr. Estrada, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
We'd be asking the court to defer adjudication on this matter for 15 months, but to impose a fine of $500, 50 hours of community service, in order that Mr. Estrada install an interlock device on any vehicle he owns or operates, as well as impose standard standard DWI terms and conditions.
Okay. Is there any, what's the court process, excuse me?
39%.
97?
Yes.
Yeah, 97.
Mr. Estrada has a question, Your Honor.
Oh, it's, for him.
Oh, what's
Oh.
that?
Are the, like, classes can be online or?
Classes.
He
Oh,
can
the-
find that out from the probation officer.
Oh.
Okay, Mr. Estrada. State is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs of $397. You'll be required to pay DWI conviction fine fee of $100, probation fee of $60 a month, your nurse's fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total amount in installments, that is a total amount that you will be required to pay each month while you're on probation, is $153 a month. Will you be able to pay the $153 a month?
Yes, Your Honor.
You'll also be required to perform 50 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You're required to attend a complete DWI education class, have an alcohol assessment, and follow all the terms and conditions of this DWI probation.
Mhm.
Mr. Ortiz Estrada, do you understand the state's offer?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Ortiz Estrada, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Ortiz Estrada, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure, whereby your record will be sealed to the general public. You can talk to an attorney about the non-disclosure. Now, Mr. Ortiz Estrada, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day. Okay.
There was a guy, Brady, we don't have a plea for him.
Okay, let me, I'm gonna do Brady. Johnny Lee Brady, how you doing, Mr. Brady?
Good, how are you today?
I'm doing fine, thanks for asking. Mr. Brady, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Mr.
sir.
Brady, you may put your hand down. And again, Mr. Brady, how are you doing?
Good.
That's good. Now, Mr. Brady, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line as titled Defendant?
Yes, sir.
All these your initials on the line that state you would like to waive your right to attorney and represent yourself.
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of entering guilty plea or proceeding trial. You recognize this document?
Yes, sir.
And is this your signature on the line as titled
Yes.
Defendant?
Yes, sir.
Now, Mr. Brady, before you sign any initial of these documents, did you read the document?
Absolutely,
And did you understand what you read?
absolutely.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, now, Mr. Brady, you've talked to the prosecutor in this case,
Yes, sir.
and you have not been able to reach an agreement?
That's not entirely what happened, Your Honor. Mr. Brady claims that he has roughly about 30 days in jail
180 days in Galveston County.
Oh,
that, and we
Hold
need
on,
to
let
be able
me
to
see.
confirm
Let me
that jail
see.
time
hold on, let me
before
see.
we can make an offer. So it would be a time served offer if that's indeed true.
Okay. Let's see if they got it. Something. Did you look up the case summary? That's where it is. That's where it usually is. Let's see. Loading case summary, please wait.
We can see the county time on our side.
Okay, let's see. He posted a bond, surety bond. Yeah, the only thing they have is posted. Arrest date, and he bonded out. Most, I don't see a. You might have been in. You might. Bonding company L. Reed, surety bond
Yeah.
released.
And always, it always makes sense.
Released 8/18/26. What's that?
Half the time, it's just like, oh, I can't give you that information right now.
They-
That's today.
18, that's today, yeah.
Yeah.
That's what we're doing. That's what we're trying to do.
I'm looking at saying some, the surety released. Hold on a minute.
Maybe the bond company released the bond because I came to court.
What happened?
Granted disposition. Oh, I'm looking at, no, I'm looking at the wrong person. Hold on. No, that's something else. Brady, let's Johnny Lee.
Judge, if the court would give us a brief reset, then the state could confirm
Okay, hold on, let's see, might be with. Let's see. Oh, here it is, right? Yeah, he was, let's see. They received a capious June 22nd, 2026, asked to call later today. Subject is in custody in Galveston County. Not booked as of 4:33 p.m. Subject is booked 6/25/2026. Subject is ready for pickup 6/25/2026. Entered all information 6/25. Bond received. Subject posted a bond of 6/25/2026. Hold on, there's another, there's somebody else, another out of county. Oh, he was in Galveston again.
Yes, sir.
Let's see, in April 20th, I received a teletype. On the 20th, request to send us a teletype. Call Galveston County. Subject posted bond 1,000 on the 4/20. Request they send. Bond waiting for mail post bond. Received from Galveston County. Yeah, I don't see where, yeah, they would have to look into that because it looked like it's just like one day. Galveston per bond was, they said you had posted a $1,000 bond on the 20th of April. We received a teletype on the 20th of April. But I don't know if you had been in there before then, and then they sent the teletype right before you got out.
When are you alleging that you first went to jail for the 180 days?
To be honest, I'd have to look at my own records.
Yeah.
Offhand.
Yeah, no, he has to be reset.
Yep.
They have to reset him. Okay. they're gonna reset you.
Yes, sir.
Just reset him the next week. And that should be, we should be able to we should know something by next week.
Hey, would it be possible for me to do like a Zoom on,
No, if not, if your case is gonna get taken care of, you gotta be here in person.
okay,
Yeah.
all right.
Will you be able to come back next week?
I mean, I will, yes, but I live in Houston, so this is.
Oh, that's just, up the road. So it's- Mr. Giovanni Battiel, this is cause number 26CCCR 1720. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. I have two documents before me. First document is judge's explanation on rights of defendants without attorney. You recognize this document?
Yes, Your Honor.
And is this your signature on the line as titled defendant?
Yes, Your Honor.
And are these your initials online that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled waiver of counsel for purposes of entering guilty plea or proceeding trial. You recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
Now, before you sign and initial these documents, did you read the document?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. Battiel, I need to ask you some questions before we go any further. And the questions. Okay. Okay, now the questions that I need to ask is pursuant to the case of Ferretta versus California, 422 United States, 806, that's 1975 case. First question, have you ever studied law?
No, Your Honor.
Okay. Have you ever represented yourself in a criminal action?
No.
Okay. Do you understand the charge that has been filed against you? Do you understand what you've been charged with?
No.
Okay. Okay. So if you don't understand, so you don't know the punishment range for the offense that you've been charged with, is that correct?
Yes.
And are you familiar with the exact legal elements of each of this charge?
No, Your Honor.
Okay. Now, do you realize that if you found guilty of this offense, hold on, let me pull it up right quick. The offense is a Class B misdemeanor, knowingly altered a license plate. Do you realize the punishment range? The punishment range is 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. That's the punishment range. Do you understand that?
Yes, Your Honor.
Now, do you realize that if you represent yourself, you are on your own? As a judge, I cannot help you in any way. Do you understand that?
Yes, Your Honor.
Are you familiar with the Texas rules of evidence in Texas case law?
No, Your Honor.
Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. Now, for example, do you know how to conduct a voir dire examination?
No, Your Honor.
And do you know what are the grounds for excusing a juror for cause?
No.
Do you know what is hearsay?
No.
Okay. Do you know what are some of the exceptions to hearsay?
No.
Do you know what is the proper, what is proper impeachment of a witness?
No, Your Honor.
Do you know when character evidence is allowed? Okay. Do you know when and how to make proper objections?
No, Your Honor.
Okay. Do you know when and how to move for a directed verdict?
No.
Do you know how to offer evidence to protect the record for appeal?
No.
Do you know the proper grounds for a mistrial?
No.
Are you aware that the failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
Yes.
Do you know how to request and object to a jury charge?
No, Your Honor.
Are you familiar with the Texas rules of criminal procedure?
No.
Do you realize that those rules govern the way in which a criminal action is tried in court? Okay. Now, I must advise you that it is my opinion that you will be far better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You're not familiar with the court procedure. You're not familiar with the rules of evidence. I would strongly urge you to not try to represent yourself. Now, in light of the penalties that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer? Okay? Is your decision entirely voluntarily on your part?
Yeah.
Okay? Now, I find that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. So, Mr. Badiel, your case is going to be reset. You'll have an opportunity to go to the district attorney's office and have access to the discovery. The discovery is the evidence. They'll give you access to it. And that will be, you have to set up an appointment with the prosecutor so you can go in there and review the evidence. Okay? All right. So your case is going to be reset. You're going to get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day.
Thank you, Your Honor.
You're welcome. Court being recessed till 1:30 so that we can resume with the trial. Prosecutors, you're excused.